Okay, so welcome to yet another edition of this copyright class. In today's class, we're going to be continuing our investigation of copyright originality and the subject matter of copyright protection by looking more specifically at the elements of originality, independent creation and creativity, and how they actually work in practice. So as you'll recall, at least in a kind of abstract theoretical sense, in order for a work of authorship, or more precisely, an element of a work of authorship to be original and protected by copyright, it has to be both independently created by the author of the work and have some modicum of creativity, whatever the hell that means. So let's start with the concept of independent creation. What does that mean in practice? Well, theoretically, it just means not copied from some previously existing work of authorship, right? So you can copy something from something that's not a work of authorship and obtain copyright protection in the copy. The only problem is you can't copy something that's already a work of authorship and claim copyright protection in it. Or rather, maybe to put it another way, you can only claim copyright ownership in the elements of the work that you've generated that are new and different from a previously existing work, or at least that you didn't copy from a previously existing work. And there's, of course, the peculiarity that under copyright law, novelty isn't actually required, right? So a work can be protected by copyright, even if it isn't novel, so long as it isn't actually copied from another previously existing work. So if you generate a new work that's identical to a previously existing work, but you didn't know about the previously existing work and you didn't actually copy it, you can still claim copyright protection, even though the elements are actually identical, right? So there's a state of mind element to copyright protection, which doesn't exist in other forms of intellectual property. Like, for example, patent requires absolute novelty, right? You can't claim a patent on something that somebody's already invented and distributed to the public, even if you didn't know about their invention. So I think the best way to kind of investigate both independent creation and creativity is to look at it through the lens of a few different cases, which illustrate how courts have, for better or for worse, applied both of these concepts in practice, or courts and agencies. And we're looking at an agency decision in today's class as well. So to begin with, in Alfred Bell v. Catalda, really important Second Circuit case, kind of thinking about copyrightable subject matter and what aspects or elements of a work can be protected in the first place, looked at this situation where there's a Thomas Gainsborough, a very famous Thomas Gainsborough painting called The Blue Boy. It's actually in the Huntington Library in Los Angeles, and very popular painting, and highly in demand for reproductions of this painting. So a company created a reproduction of the painting in a medium known as mezzotint. Right, so this is a method for reproducing paintings. It's not photographic. It uses a bunch of different kind of mechanical techniques that enable the mezzotint artist to reproduce more faithfully the painterly qualities of a painting in a way that other mechanical forms of reproduction cannot, right? So the plaintiff here reproduces the painting in the form you see on the right and sells copies to the public. And then the defendant, right, also wants to get in on this market, right? They're like, oh, wow, they're selling a lot of these mezzotint reproductions. We should get in on this as well. They have a cheaper, easier method of creating reproductions, but they don't want to go all the way to the Huntington Library, get access to the painting, et cetera, et cetera. They just buy one of these mezzotint copies and create a reproduction of that, right? They use their method to create a reproduction of the reproduction created by, well, effectively their competitor. And the competitor sues. They say, hey, you copied our mesotent. You're not allowed to do that. That's copyright infringement. And the defense is, look, the painting in question, Gainsborough's The Blue Boy, is in the public domain. It's not protected by copyright at all. So you created a mesotent copy of The Blue Boy, but it's a public domain image, it's a public domain work. You can't claim copyright in something that's in the public domain. And the court says, not so fast, right? Yes, it's a reproduction of a public domain image, but it's a reproduction that involves aesthetic creative decisions made by the mesotent artist. So we have echoes here of Burrough-Giles v. Cerny, right? In effect, the court is saying, look, copyright can't protect the painting, The Blue Boy, but it can protect the mesotent reproduction of The Blue Boy insofar as that mesotent reproduction includes new and original elements that weren't present in the original. In other words, insofar as the aesthetic decision-making of the mesotent artist affected the appearance of the mesotent, those aesthetic decisions can be protected by copyright. And then the court says, look, the problem here is the defendant copied the mesotent, not the original. So it's harking back to Holmes's observation in Bleistein v. Donaldson, right? Anyone is free to copy the original. You're just not free to copy the copy. Well, what did they do here? They copied the copy. They copied the mesotent. And the court says, look, you weren't allowed to copy the mesotent because the mesotent has sufficient originality to be protected by copyright. The bar for originality is really low, and the mesotent just clears it. And you copied that mesotent. Therefore, by copying the mesotent, you infringe on the very thin but still in existence copyright in the mesotent. Now, one might ask, for example, are we sure that the mechanical reproduction actually copied the original elements of the mesotent in such a way as to constitute copyright infringement? And more than that, does this make any kind of sense, right? To allow people to claim copyright ownership in a public domain work simply by virtue of creating a reproduction? And what exactly is copyrighted about the reproduction? If somebody else creates a mesotent that looks really similar, is that non-infringing, or does it get a separate copyright? How should this work in practice? Well, we see a very different approach when it comes to more mechanical forms of reproduction in Bridgeman Art Library. So what happened here, Bridgeman Art Library is essentially a company that is in the business of selling reproductions, photographic reproductions of works of art, and specifically early digital photographic reproductions of works of art. And Corel is a big software company. WordPerfect, among a bunch of other things that you probably never heard of because they were obsolete before you were even born. But in any case, Corel starts selling images, or providing to its customers images of these public domain works of art. But it turns out that these images were originally created and distributed by Bridgeman Art Library, and they sue Corel for copyright infringement, essentially on the same theory as Bell v. Cataldo, saying, look, we created photographic reproductions of these paintings that involved aesthetic decision-making on our part. Therefore, we can claim copyright ownership in the photographic reproductions we created, not in the works of art, in the photographic reproductions. And the court responds, hey, no way. Right? Not a chance, right? These photographic reproductions are intended to reproduce the appearance of the original work of art as closely as possible, right? These are just literal reproductions of those works of art. You are not adding any original content whatsoever. Therefore, you cannot claim copyright protection in reproductions of these public domain paintings because you're just taking that intangible work of authorship and translating it from one medium, painting, to another medium, photography, right? That's not a new work of art. You haven't added anything original. All you've done is copy something that already existed. That's not protectable by copyright. Your photographs, while valuable and useful, are not copyrightable works of authorship because you haven't added anything to them that copyright can protect in the first place. So I ask you to reflect on the question, are Bell v. Cataldo and Bridgeman v. Carell consistent with each other? And how should we think about what it means to talk about independent creation, right? And what constitutes a copyrightable element? In other words, it kind of seems like the better the reproduction, the more accurate the reproduction, the less protection exists, the more imprecise the reproduction, the more copyright can exist. In other words, in a sense, copyright seems to protect the imprecision or the differences between the original and the copy, and to disappear as the original and the copy come to merge together and look identical. Okay, well, let's also think about creativity, or the requirement of creativity for a second. So a lot of scholars have kind of more or less tacitly arrived at the assumption that creativity is basically a dead letter. It doesn't really mean anything, right? Supreme Court said in Feist v. Rural, creativity is a requirement for copyright protection, but you don't need very much, only a tiny little bit, just to dabble, do you? A little tiny itsy bitsy bit of creativity, whatever that is, and your work is protectable by copyright. Smart Money says that basically creativity says everything's protectable except the phone book, which seems bizarre, but okay. Whatever. However, the Copyright Office has not taken it that way. And in fact, the Copyright Office has imposed a much higher bar on creativity than it seems like the Supreme Court has endorsed and the federal courts have tended to pursue. And we can see this in practice in the registration application, which was denied around the Dubai frame sculpture. So what happened here was the author of the work entered a sculpture competition in Dubai, and his winning entry was called Dubai Frame, and his proposal was basically to build a giant picture frame in the outskirts of Dubai that visitors could look through to frame the city through the picture frame, and also go up in the frame and walk along the top and be shops and all this kind of stuff. Anyway, Dubai was like, yeah, we like it, we dig it, we're going to build it, but we're not going to pay you for it. Right. And understandably, the architect was none too pleased with Dubai's refusal to pay him for producing this particular monument, and tried to bring a copyright infringement action against him. The problem is that in order to bring a copyright infringement action, you have to register your work of authorship, or at the very least, you have to apply for registration, and whether or not the copyright grants the registration application, once they've acted on the application, you're then permitted to sue, and you can relitigate registration in the courts as well. Well, the Copyright Office denied the architect's registration application, saying, look, what you're registering is the work of authorship that you offered as a drawn design on the left, and that's just a square. Right? You're trying to register a square. You can't register a square. And the artist, the architect said, no, this is like, it's a site-specific square. It's a site-specific frame. It's intended for a specific place, and it's got all these kind of meanings embedded in it. And ultimately, the Copyright Office says, no, that's not how copyright works, right? Copyright protects works of authorship, not the context in which those works of authorship are presented, but works of authorship in the abstract. And what you're trying to register is literally just a frame, and that's it. That's not original, and we're not going to let you register it, right? And obviously, architect's not very happy about that, and it seems like his crusade to pursue a copyright infringement litigation didn't really go anywhere further after that point. But we can see here the Copyright Office kind of taking a harder line on registration and on the creativity requirement than other courts. But I might ask, like, did the Copyright Office really need to go with creativity here, or could they just have said, there's nothing independently created here. All you've done is offer us a frame. Frames already existed. You haven't created anything new. You just made it a lot bigger. But copyright doesn't care about how big it is. A frame is a frame is a frame, no matter what size the frame is. Did it need creativity? I don't know, but that's what the Copyright Office went with.